Lovable just got a trademark cease and desist letter from Figma for use of their dev mode trademark. What does it mean? What should you do if you find yourself on the receiving end of one of these letters? In this video, I'm going to address the letter, the dev mode mark's validity, the Twitter circus that ensued, and why to be wary of the cease and desist letters when they're written in this kind of a nice tone. I'm Dennis Walsh, a software developer and intellectual property attorney. I made this channel to teach fellow software developers about legal issues that affect software engineering. If you find this video valuable, please, I'd greatly appreciate a like and subscribe because I'd like to help more developers and I'm tired of my work going into the void. Lovable is one of the upstart AI coding tools. To me, it looks like a more end-to-end or hand-holdy version of Bolt.new. Lovable created a feature called Dev Mode to let their customers edit the underlying generated code. However, Figma, the design prototyping giant, also uses the term dev mode to inspect designs and translate it into code. Last year, Figma registered dev mode with the US Patent and Trademark Office. So this letter predictably sent tech Twitter into its typical tailspin with commentary all over. Specifically, how can something so stupid get a trademark? I'm going to get into it, and when I'm done, I think you will feel better about trademark law as a whole. And while I have opinions on trademark policy and this case specifically, and if you want to know that, I'll do another video, let me know. But my goal in this video is just to provide the facts and the law so that you can have a well-formed opinion. The first thing to know about trademark law is it is not patent law. People get requirements and remedies confused constantly. Patents give the holder a right to exclude others from practicing the claimed inventions. It takes years to get a patent, but at the end of it, the patent holder has a lot of power in court. That is not true for trademarks. With trademarks, there are three levels. There's common law, supplementally registered, and principally registered. You get a common law trademark for simply placing a trade name into commerce. You don't need to register a thing. The downsides, though, if you don't register it in the US, you're geographically limited into areas where you've given constructive notice of the mark's use, essentially in your little area. And there's no presumption that you have a right to use it. For supplemental registered marks, the bar is low. Essentially, you can get any mark on the supplemental register so long as it's not likely to confuse with a prior trade name, isn't immoral, deceptive, or of a US president during his widow's life without her consent. In other words, the supplemental register is a free-for-all. So what protections does it offer? As you may now anticipate, not a whole lot. Courts assume that the owner of a supplementally registered mark has a right to use it. The mark has nationwide enforceability, the filing date for the first use of the mark, and that's about it. In other words, it's a pretty good shield against infringement actions, but it is not a good sword. A supplemental mark still needs to prove validity and distinctiveness. So contrast that with the principal registered mark. There are many bars to principal registration, but for this discussion, descriptive marks do not qualify. There are levels to this game. The more fanciful the name, the more legal protection you get. The law school examples are Apple and Kinko's. Apple is afforded great protection because it's a non-descriptive tech name. Don't name your next AI startup Apple.new, but you could name your furniture company Apple Creations. So then contrast something like Apple with Kinko's. Kinko's was a national mailing and print shop that was bought by FedEx, but the name was completely made up. Therefore, you couldn't even call your furniture store Kinko's. If the mark is on the principal register, then the court will assume that the mark is valid and distinctive. That is a huge advantage by shifting the burden from the mark holder to show that it's valid and unique to the defending party to show that the mark is not valid. And after 5 years on the principal register, given certain conditions, the mark can graduate to even higher protections. So with all of that factual and legal background, you probably know where this one's going to head. When these cases drop on an IP attorney's desk, the first thing we want to do is look at what is actually being claimed. So we go to the Trademark Systems Documents tab, where they give you the complete record of the trademark's prosecution. For Figma and Dev Mode, they filed to be on the principal register. And then, hope you're sitting down, Twitter know-it-alls, the USPTO said exactly what all of you have said. Quote, in this case, both the individual components and the composite result are descriptive of the applicant's goods and/or services and do not create a unique, incongruous, or non-descriptive meaning in relation to the goods and/or services. Thus, altogether, the wording dev mode is merely descriptive of the applicant's goods and services because the goods and services presumably have a designation condition for the developers to perform and/or respond to tasks and problems related to development. Therefore, applicant's mark merely describes applicant's goods and services, and registration is refused under the Trademark Act. After that rejection, Figma could go back to the trademark office, say the trademark office rejection was wrong, put forth additional arguments and evidence. But do you think that's what they did? Not at all. They amended to the supplemental register. This supplemental registration provides Figma with a great shield against someone else's infringement claim, but as we discussed earlier, does very little to help them prosecute an infringement claim. The issues that everyone raised in the comments, validity and distinctiveness, have not been decided, and the court will not give Figma any deference. This is not the arrow most of you think it is. So there's one more thing I'd like to point out. When I was at my previous law firm, one of my specialties was declaratory judgment complaints. Courts do not decide hypotheticals. You can only bring in a case when there's a controversy. Cease and desist letters can be harsh enough that the courts will find that there is a controversy and the defending party can sue the alleging party for a declaratory judgment of non-infringement. So in this case, Figma, if they wrote it harsh enough, could be dragged into a lawsuit they may not have wanted in Lovable's preferred home court. In fact, I used to disguise patent infringement letters as opportunities to make the infringer's product better. Hey, we have some great IP that could really make your product so much better, with the in-between the lines reading of it being, if you don't, you're going to be sued. I bring this up as a cautionary tale to not dismiss letters that come off as polite or even friendly. It's for a reason. Now that you know the whole story, what do you think? Is Figma a bully? Are they justified? Let me know down in the comments. I'll give you my thoughts there. And then let me know what you would like to see for future videos. And of course, please subscribe for my future videos. I'm working on a copyright and trademark video concerning the AI generation and Studio Ghibli, and I'll go over the latest Reuters AI training lawsuit.